talked about the Ships for America Act, what's happening today, kind of the history and what has brought us to where we are, and now we put some numbers on ships and CapEx. And now it's sort of the exciting part to hear how various parties can participate in this. And to illuminate us on this, Rob Lustrin, Counsel, Head of Shipping Capital Markets at Reed Smith, will let us know what every non-U.S. shipowner, investor, and lender needs to know about participating in the U.S. maritime markets. Rob?
Okay.
Green button.
Gotcha. Okay. Good afternoon, everyone. Very happy to be here to warm up for Mr. Ross. Thank you to the Marine Money team. Thanks, Mike, for that kind introduction. I'm Rob Lustrin. I'm a member of the Transportation Industry Group at Reed Smith. And if you're not familiar with our law firm, we're an international law firm with over 1,700 lawyers in 32 offices around the world, serving many different industries, and are very proud of our global prominence and focus in shipping and aviation, including our U.S. maritime practice here in New York, Houston, Miami, and Los Angeles. That was really fascinating, the last several speakers. It's great to hear how our industry is really striving to regain prominence globally and here in the U.S. Even before our U.S. elections, of course, and before the change in administrations, we have observed an increased interest among our private equity clients, primarily European-based, in investing in the U.S. maritime industry. And the U.S. has all the necessary inputs, to sustain a vibrant maritime industry. Yet we've experienced a steady decline over the years in ownership and operation of commercial seagoing vessels, and the U.S. coastwise trades continue to have legal barriers to entry in terms of foreign ownership limitations, some of which may be addressed in the Ships for America Act. So then, what should everyone know about what's currently the regulation in the U.S. on investing in shipping? And yes, we're looking forward to the Ships for America Act and all that it may hold. But where are we at this very moment, and how can an owner or an investor get into U.S. shipping now under the current framework? To note, people unfamiliar with U.S. shipping often confuse the requirements for flying the U.S. flag and the additional requirements for trading between U.S. ports. The U.S. coastwise trade is indeed protected by the Jones Act, which is, as was referred to earlier, Section 27 of the Merchant Marine Act. However, while registering a vessel in the U.S. is a necessity to engage in U.S. coastwide trades under the Jones Act, a vessel may indeed fly the U.S. flag with more relaxed foreign ownership requirements and secure a number of benefits outside of the Jones Act, and we will explore some of those differences. But I thought it was a really good idea, since we have many young, fresh faces here and many people who have come from overseas, to start with an overview of the regulations, and then we can have a brief discussion about opportunities. I'd like to also note that my presentation does not constitute legal advice, and you should seek legal advice and as you engage in your activities. So first, what is it to register a vessel under the U.S. flag? First, a vessel must be owned by a documentation citizen, which is also referred to as an eligible owner. So there are different categories in the regulations to be an eligible owner or documentation citizen. If you're a partnership, the general partner must be a U.S. citizen. If you're a corporation, the company must be incorporated in the U.S., and the person serving the functions of the chairman and CEO must be U.S. citizens. The number of directors on the board that are not U.S. citizens can't exceed a minority of the number needed to form a quorum for meetings and actions of the board. LLCs, which is a primarily new construct, can either be treated as a partnership or a corporation depending upon how they are structured. Typically, if an LLC is member managed, it would be treated as a partnership. And if it's manager managed, meaning by a management company, it would likely be treated as a corporation. Trusts, if you're in a trust format, each trustee must be a U.S. citizen, and each beneficiary with an enforceable interest in the trust, and that's the way the words work, is either a U.S. citizen or if you don't prove that, a trustee has to certify in its application for documentation that no beneficiary that is not a U.S. citizen wouldn't hold more than 25% of the power to influence or limit the autonomy of the trustee. So, very interestingly, all of these different categories really go towards keeping effective, keeping control by U.S. citizens. U.S. flag crewing requirements. This is quite interesting and often misunderstood. 100% of licensed officers must be U.S. citizens. Unlicensed crew, however, can be comprised of both U.S. citizens, up to 25% comprised of lawful permanent resident aliens, green card holders, or foreign nationals enrolled at the U.S. Merchant Marine Academy at Kings Point. So that's also quite an interesting way to go. So when you go to register your vessel under the U.S. flag, you have to have a trading endorsement. If you're in a commercial trade, you can have one of 3 trading endorsements. A coastwise endorsement, which allows for commercial transport of cargoes in U.S. waters, and the U.S. exclusive economic zone, which is the 200 nautical mile zone around the coastline. And coastwise trading is the type of trading under the U.S. flag that is protected by the Jones Act. So that's cabotage trading between U.S. ports. You can get a fishery endorsement. This allows for fishing and landing catch in U.S. waters and the U.S. exclusive economic zone. That is not, again, that's not Jones Act shipping. That's something a little bit different. Registry allows a U.S. Coast Guard documented vessel to engage in international and foreign trades where a coastwise or fishery endorsement is not required. So those are the things that we're really talking about in our aspirations for the future of the U.S. flag, which is to grow the fleet using the Ships for America Act to engage in international and foreign trades. And then there's, of course, recreational endorsement, yachting, and pleasure craft that are not conducting commercial enterprises. So here's, again, I know it's a little fundamental, but I think we should all kind of clear this up. Can a foreign-built vessel fly the U.S. flag? We get this question frequently. Or can I sell my foreign-built vessel to a U.S. owner or operator so that it can be, imported into the U.S. flag? The answer is yes. A foreign-built vessel can indeed fly the U.S. flag. The vessel must be registered with the Coast Guard and meet those U.S. crewing requirements. The vessel must meet the Coast Guard's safety and operational standards that are necessary to fly the flag, which tend to be more stringent than in certain other jurisdictions. And I will say that in this past May, the Coast Guard published new guidance relaxing some aspects of these inspection and other requirements that are necessary to reflag a vessel into the U.S. in an effort to attract vessels into the flag and to expand the flag. The U.S. Maritime Administration, or MARAD, also can certify vessels to fly the U.S. flag, not just the Coast Guard, when the vessels are enrolled in sea lift support programs, including the Ready Reserve Force. So that's also quite an interesting, little-known fact. So, by the way, here's Senator Jones. Can a foreign-built vessel engage in Jones Act trades? The answer to that is no. The U.S. coastwise trading, as I've mentioned, is protected by the Jones Act, which means vessels transporting merchandise from one point to another in the U.S. has to be registered under the flag and carry a coastwise endorsement, each of which has these requirements. In addition to being a documentation citizen, that's what we spoke about before, flying the flag, being qualified, an entity that owns a U.S. flag vessel to be qualified for the coastwise trade must be owned at least 75% by U.S. citizens at each level of ownership. So you have to kind of look up the chain, and at every level of ownership, you have to have at least 75% U.S. citizens in that structure. How do you measure U.S. ownership, the 75%? If it's a corporation, you look at equity interests, shares in a corporation, for example. You look to voting power, whether by equity ownership or otherwise, including a contract, an understanding, or an arrangement, a voting proxy, a voting agreement, whether or not voting power over shares are conferred. Interestingly, there's a catch-all, any other means of exerting control over the entity. And for trusts, each trustee must be a U.S. citizen, and each beneficiary with an enforceable interest in the trust must be a U.S. citizen. You don't kind of get that little bit of a relaxation that you would in the flagging, instance, where the trustee can make a certification that they're not under influence. Actually, you have to have all trustees that can enforce the trust be U.S. citizens. So last line here is just to summarize. The Jones Act limits coastwide trades to vessels built in the U.S., documented under the U.S. flag, meeting the crew requirements, and legally and beneficially owned at least 75% by U.S. citizens. So we have a lot of public company representatives in the room and people that aspire to go public. How can a publicly traded company meet the 75% test? So the U.S. Coast Guard has noted in some guidance that it will look for due diligence and timely good faith action by every company that seeks to participate in restricted trading privileges using means that are available to the company and at its disposal in order to satisfy U.S. citizenship requirements. So the U.S. Coast Guard is saying, look, you got to do your diligence. You have to use all of the tools that you have in your toolbox to figure out who your shareholders are and make sure that you meet these requirements. Public companies often incorporate ownership restrictions and shareholder certification requirements in their certificate of incorporation or bylaws, their constitutive documents. Public companies have some tools available to it that maybe private companies don't. They can look to addresses of individual holders appearing on the share register or on those appearing on a list of non-objecting beneficial owners that hold in street name. It may be able to poll brokers that hold shares in the corporation, and also is afforded public filings that it can look to. So public companies can look to SEC-filed shareholder reports of beneficial ownership, such as Section 13 filings, Schedules 13D and 13G. And ownership between foreign and U.S. citizens can also be established, and many public companies do this. You can bifurcate your share ownership through DTC in what's called a Seg 100 account, a segregated account. So U.S. citizens can hold one form of the security with a separate QSIP number, and foreign citizens can hold another, let's call it tranche, so that public companies can easily ascertain who's a U.S. citizen and who's not, based on certifications that are made when when shares are purchased or transferred. So you don't meet the 75% test. What do? You want it. You're a foreign investor or institution. What can you do? One, you can qualify as a, quote, qualified leasing company that will entitle you to own the vessel, obtain a coastwise endorsement if you meet certain requirements, and then bareboat charter it on to a U.S. citizen. And that bareboat charter would have to be on file with the U.S. Coast Guard. So to be a qualified leasing company, you have to be a leasing company, a bank, or a financial institution, own or hold a beneficial interest in the vessel solely as a passive investment, not with the intent to operate it yourself. You can't operate any vessels for hire and not be an affiliate of any person who operates a vessel for hire. So you have to do it purely as a financial business and not as an operating business. And again, be independent from and not an affiliate of the charterer of the vessel or any other person who has the right to control the movement of the vessel. Now we're talking about a sub-charterer or a manager of the vessel. The minimum length of the charter to qualify for this treatment has to be 3 years, and the bareboat charterer must have full possession, control, and command of the vessel. So possible there are foreign banks that, set up, Jones Act qualified leasing companies to do this business. But again, you have to jump through those hoops to do it. So what else can you do? Well, you can just do the traditional thing. You could be a traditional lender if you want exposure to the U.S. market. There is no prohibition on lending money to the owner of a U.S. flag vessel, and that includes Jones Act vessels. So a foreign lender can hold a mortgage, but the vessel can't be operated after, you gotta be careful, can't operate the vessel after arrest or foreclosure if the U.S. citizenship requirements are not met. And there are special rules that apply in the case of a seizure or a foreclosure. Okay, so here's some other ways that you can help yourself out if you don't have 75% of the equity in the hands of U.S. citizens. What do? How do you structure it? Well, there are traditional methodologies that can be used that mathematically can give one more than more economic effect of ownership without having voting power. One of which is layering up. As I said, you have to meet the 75% test at every level, but if you maximize your foreign ownership at each level, you could effectively achieve a greater than 25% interest. And secondly, and more importantly, you can buy warrants. So in April 2023, the Coast Guard confirmed that in addition to owning up to 25% of the common stock of a coastwise vessel owning company, non-U.S. citizens can own an unlimited amount of non-voting warrants to purchase common stock, and those can be bought and sold, so long as the warrant holders don't have voting rights, they can't exercise preemptive rights. In other words, so you can't have something that says that you can get a hold of more than 25% of the voting power. And you don't have a right to receive notices of stockholder meetings. Warrant holders are not eligible to receive dividends or other distributions. They would have to exercise to that, and then you'd have to be mindful of your ownership percentage. And warrants may be transferred, but only subject to provisions that restrict the transferees of the warrants to be able to exercise them only if the result is that it would not cause the U.S. citizenship ownership to breach the relevant threshold, meaning that foreign owners would own more than 25%. So the flip side here is that it can be expensive to operate in the U.S., as you'll need to abide by labor laws, minimum wage laws, safety laws, which are a little bit burdensome as compared to some overseas, both at the federal level and the state level. U.S. port fees can also be expensive in relation to other countries. Also, dealing with the U.S. Coast Guard, you need to have the tools to do that and to have, oftentimes, to have the know-how. And I would say that can present challenges, and I would encourage you to speak to your professionals in order to educate you on how to set these things up effectively. So what happens if you blow it? I mean, that's really another question. Sanctions for violating the Jones Act are severe. Merchandise, that's what it's called in the legislation, merchandise. Merchandise transported in violation of the Jones Act is subject to seizure or a fine of up to the cost of the transportation or the value of the merchandise, whichever is higher. In a 2017 case, which was kind of heralded at the time, value was measured by fair market value, which can go either way depending upon how you're looking at it at a given point in time. If you're an ineligible owner, so you made a mistake, you applied for a certification, turned out to be ineligible, or failed to have proper documentation, the fine can be as high as $15,000 per vessel per day for the amount of time that that vessel is trading in violation of the Jones Act. That's $5.5 million per year per vessel. And if you have a fleet of 5 vessels, say, and don't meet the citizenship requirements, that's about $25 million per year. So as you can see, one needs to be quite careful in making sure that you meet the requirements. If you misrepresent the facts on an application, it can also be potentially a criminal violation under the False Statements Act and can probably land you in prison, so you would want to avoid that. But let's look at the bright side, as we've heard today. The U.S. welcomes you and welcomes inbound investment. The U.S. administration, and we've heard it here today, Senator Kelly was here, there's a big buzz around the Ships for America Act. It's been in the news constantly. The U.S. administration is on board and has elaborated a policy to revitalize the shipbuilding and maritime industry here in the United States. The president has publicly applauded inbound foreign investment that brings jobs to the U.S. across various industries. And I'm sure that everyone in the room will be very happy when we're able to attract a great amount of investment into the U.S. flag and into the U.S. And of course, Wall Street is watching. We're very, the Wall Street community is very eager to get involved and to assist in foreign inbound investment. So feel free to talk to your friendly neighborhood investment banker and get some deals flowing. So thank you very much. I appreciate your attention. And back to the McCleary brothers. Thank you.